Hello, my name is Richard Albert. Today is Friday, September 19th, and I'm here with Carlos Bernal, law professor at Macquarie University in Sydney, Australia. And today Carlos is joining us to discuss Colombian constitutional law. Carlos, thank you for joining us today for our third installment in our video interview series here at iConnect.
Thanks to you, Richard. Thank you for giving me this opportunity, and hello to everyone.
Thank you. Let's begin. Is there a model of constitutional design that is specific to Latin America?
Yes, indeed. This model is called the New Constitutionalism. And this model arose in the late 80s and the early 90s. And some scholars link this model to the transition to democracy of some of the countries in Latin America. And this model has been entrenched in some of the new constitutions that have been enacted in Latin America. For instance, the Colombian constitutions in 91, the Ecuadorian constitution in 2008, and in constitutional amendments in Argentina and Mexico and other countries. And the main features of this model are the following. The first one is that the principle of constitutional supremacy is accepted, it's fully accepted. This principle existed formally since the 19th century, but in the legal system, actually there was a mix between the principle of constitutional supremacy and the principle of legislative supremacy that some of the countries in Latin America, they inherit from France. As you know, in Latin America, the system of law is the continental law. And in many countries, the French civil code was replicated. And one of the ideas behind this replication in the private law was accepting the supremacy of the legislature. Now, in this wave of new constitutionalism, the principle of supremacy of the Constitution is taken seriously and also enforced by the creation of new constitutional court and the attribution to the power of constitutional review to Supreme Courts, such as the Supreme Court of Argentina and the Supreme Court of Mexico, and the actual exercise of those powers by the court to control government and the Congress.
Could you say a bit more about the role of the court in this new model of constitutional design, specifically the role of the Colombian Constitutional Court in Colombia?
Yes, the role of the court, of the Constitutional Court, is central in this new model. On the one hand, the court has the power to enforce directly constitutional rights, even against the legislature, even against the Congress. And not only against the Congress, but also against the public administration, against the judgments of the ordinary justice. For instance, there are cases in which the Constitutional Court enforced the right to due process against the judgments of the Supreme Court, and also against private individuals. In Latin America, and in specific in Colombia, the doctrine of the horizontal effect of constitutional rights, Drittwirkung der Grundrechte, has been fully implemented. And in this way, the court has become central not only in the political but also in the legal system. On the other hand, one can say that one of the basic constructions laws of the political system in Latin America since the independence from Spain has been the presidentialism, and I could add the hyper-presidentialism. What does this mean? That in the political system there has been always an imbalance of powers in favor of the president. Presidents in Latin America, not only because of the competence of the constitution, but also because of the political practice, they control the legislature, and for this reason the Congress is in practice not able to render the government politically accountable. Now, one of the roles of the Constitutional Court in the new wave of constitutionalism has been to occupy this role of control to the government and to exercise the judicial and I would say also political control over the government, and this has created a balance and equilibrium between powers in some of the systems.
Sounds like a very powerful court. Could you talk a bit about the role of the Constitutional Court in the enforcement of socioeconomic rights in Colombia?
Yes, Richard. In Latin America, in this new wave of neo-constitutionalism, constitutions entrench not only liberties but also socio-economic rights, like it happens, for instance, in countries such as South Africa. But one remarkable feature of what is happening in Latin America is actually that the constitutional courts, they have an explicit and specific agenda to try to bridge inequalities in society and to fight against poverty by means of the direct enforcement of socioeconomic rights, even if this has implied to breach the principle of separation of powers, at least in the way that has been traditionally conceived, and to require the government to implement policies to guarantee the satisfaction of the basic needs for the population. And in this way, for instance, the courts, they have enforced directly those rights. They have issued commands to the government and to the Congress to allocate in the budget some amount of money for developing specific policies concerning the satisfaction of socioeconomic rights. And they have also even politically controlled the governments and the Congress and the parliaments in the way they have comply or they have been obedient to the commands that the court has issued in those judgments. This has been remarkable and is, I think, a specific feature of the new constitutionalism in Latin America.
It sounds like the court is exceedingly powerful. In a recent paper that you wrote for ICON, you discussed the constitutional replacement doctrine in Colombia, which I think is further evidence of the power, the vast powers that the Colombian Constitutional Court has. What is that doctrine?
Yes, Richard. That doctrine is a specific development of a doctrine of unconstitutional constitutional amendment. As you can anticipate, presidents, incumbent parties in power, and also the parliaments, they have not been feeling comfortable because of the role of the court trying to render all of them politically accountable by means of judicial review. Then one way in which the governments and parliaments have responded to the exercise of the power of the court has been by means of constitutional amendments. However, the courts, they have at their time responded to those powers by means of creating this specific doctrine of constitutional replacement. According to that doctrine, the Constitution grants the Congress the power to amend, to update the Constitution, but not to replace the Constitution. And this means that, for instance, the Congress is not competent to alter in a dramatic way the structural elements of the Constitution. Now, as you can see, for instance, it is very difficult to make a difference between what is an amendment and what is a replacement of the Constitution. This is a point that I discussed in that paper that has been published in ICON. Now, the point is that on the one hand, many people have criticized the exercise of this extraordinary power by the court, but other people have praised that exercise of power as a way to control what David Landau has called abusive constitutionalism. It's not a secret that in many countries, Venezuela, Hungary, also Colombia, and now Ecuador are examples. The governments in power, they have tried to adjust the rules of the political system for them to be able to perpetuate themselves in power, and also to shut down instances of political accountability and political equilibrium. Now, the court, like the Colombian court, by means of this constitutional replacement doctrine, has done a good job trying to create a possibility to hinder those attempts of abusive constitutionalism by the presidents. And one famous case is the Colombian case of 2010, in which the court struck down a law that called a referendum that was designed to enable President Uribe to run for a third term. And now this doctrine is being analyzed in other countries. Yesterday was a hearing in Quito, and the Constitutional Court is considering whether the court should use the same doctrine for the purpose of make it impossible for the President Correa in Ecuador to to amend the constitution and introduce an indefinite numbers of presidential re-elections as a possibility.
It's really fascinating. As you describe the Colombian Constitutional Court's powers of political and judicial control over the executive and legislative branches, in addition to your description of how the court can intervene in matters of socio-economic rights, not to mention the court's vast powers with regard to constitutional amendment and replacement, it seems to me that the court is very, very powerful. And I wonder what that does to the separation of powers in Colombia. The separation of powers, of course, is intended to create a balance among the branches. But here, I would suspect that some scholars, probably, and politicians for sure, have argued that there now is an imbalance of powers in Colombia.
Yes, this is, I think, the main worry of this new model of new constitutionalism. And there is a paradox in this respect, because on the one hand, everyone applauds the court for being able to create a balance of powers by mitigating the hyper-presidentialism. But on the other hand, no one knows what is the boundary for the court, or how to constrain the exercise of the court. And then in this respect, this discussion between Carl Schmitt and Hans Kelsen concerning who should be the competent authority to protect the constitution, and how the highest power in the country can be controlled is again relevant in Colombia and in other countries in Latin America.
Would you say that the Colombian Constitutional Court is the most powerful court in the world?
Maybe yes. And not only because of the specific powers and competences that the Constitution grants to the court, but also because the court has been populist in some respects. In Colombia, for instance, citizens, we have a direct injunction to claim specific constitutional rights behind the court, and the court has used this mechanism to recognize medicines, procedures, benefits concerning housing, health, etc. to the people. And for the reason, the court is a very popular institution. And also because of that, the judges of the court, they don't care to use judicial discretion in the cases. They have been acting very boldly in many cases, and in this way, for instance, there is a big difference between the judgments of the Colombian constitutional courts and some judgments of other courts, like, for instance, the South African courts. If you read the cases, the socio-economic rights cases in Colombia and South Africa, and you compare them, you will see that the South Africans and the Colombians, they have the same or similar constitutional provisions, but the outcomes of the cases are very different, because in South Africa, judges, they exercise judicial restraint, and in Colombia, not at all.
One more question, Carlos, if I could, and it's more of a matter of more currency than the ones we've been discussing. There are now peace negotiations happening in Colombia. Is that correct? What are the implications? What are the implications for the Colombian constitution of those peace negotiations between the government and the guerrilla?
Those implications are twofold. The first one is that is concerning to the question what is going to happen in the future. And many people believe that after the peace process, if there is a peace treaty, then there is going to be a new constitution. They will call a constitutional assembly and there will be a new constitution. But the actual one concerns the framework for peace. And let me explain to you a little bit what is particular in the Colombian case. There is a specific characteristic of this peace process, namely that there is not an interim constitution, but the process is conducted under the permanent 1991 Colombian constitution. The only thing that the government has arranged was creating a constitutional amendment in the year 2012 that empowers the government to conduct the peace negotiations and to grant some benefits to the members of the guerrilla that signed the peace process, signed the peace agreement. Now, the problem is that, some of the features of the permanent constitution are actually incompatible to those benefits. For instance, the Constitutional Court has said in a judgment in 2005 that a constitutional amendment would replace the Constitution and for this reason would be unconstitutional if it severely restricts the principle of equality. And indeed, at that year, the court struck down an amendment that granted some benefits for some temporary workers in the public administration to become permanent workers. Now, right now, the court is being a little bit inconsistent with that doctrine because, for instance, just 1 month ago, the court said that there is no problem at all if this framework for peace enables guerrilla members that had violated human rights and have been involved in drug trafficking or, for instance, in recruitment of children for the war. They can have the benefit to participate in politics in the future. Now, this is inconsistent with the replacement doctrine of the court, but what we can see right now is that it would be very inconvenient for the court to say that the framework for peace is not okay, and the court, for this political reason, has agreed with that framework. Now, what I claim is that maybe the use of the doctrine of constitutional replacement is not appropriate for these purposes, that we need to recognize that Colombia is actually in the middle of a process of transitional justice, and that if the court would like to exercise the powers of judicial review to the legal pieces that are produced within this framework, then the parameter to judicially review those legal pieces cannot be the permanent constitution as such, because the transitional justice actually aims to replace the constitution, but the framework for analysis should be a larger framework of international and transnational norms regulating those processes of transitional justice.
That's fascinating. So there appears to be an inconsistency as a matter of constitutional theory, but as a matter of political practice and reality, it's an inconsistency that we just have to live with.
That's right.
So before we close, Carlos, could you tell us what you're working on? What scholarship are you developing at the moment?
Thank you, Richard. Yes, I am I am finishing a paper on this topic of transitional justice and constitutionalism. And then for the coming year, I intend to finish another paper on proportionality and socioeconomic rights. And then I would like to enhance a little bit of my work in the field of constitutional change, I think, and you will relate to my proposition that this is one of the most exciting fields of our discipline. I admire your works on the field of constitutional amendment and constitutional change, and I think there is a wonderful space to contribute to a comparative theory of constitutional change, not only to what concerns to formal amendment, but in particular to informal constitutional change, which is one field that is a little bit underexplored.
I agree, and it's very exciting what you're working on. I look forward to reading it.
Thank you, Richard.
Well, Carlos, thank you very much for speaking with us about Colombian constitutional law. It's been illuminating, fascinating, and I think very important for us to know what is happening in that part of the world. So thank you very, very much.
Thanks to you, Richard, and all best to you and to everyone.
Bye-bye.
Bye.